Hi, everybody, and welcome back to the Title Minute. On this episode, we're going to continue our series on how to vest your property. And on this episode, we're going to talk about vesting or holding your title as tenants in common. Be sure to check with your CPA and estate planning attorney before you make any changes or decide how you're going to vest your real property. Tenants in common is a method of holding title in which one or more persons are able to hold title with equal or unequal percentages of ownership. For example, you could have a married couple that each own 50% of a property, then two other individuals that each own 25% of their property. So you have a married couple that own 50% of a property and two other people each owning 25% each, adding up to 100%. Tenants in common allows for owners to each have their own separate divided interest in real property. That separate interest can be transferred, sold, or conveyed by that owner of that real property. There are no rights of survivorship with tenants in common, so that interest would be passed to heirs through the probate process. Once that probate process was completed, those heirs would also own title to that real property as tenants in common. Remember always to consult with your estate planning attorney and your CPA to learn of the tax and other consequences before selecting which method in which you will hold title. Make sure you check out our series on common ways of holding title and subscribe to our YouTube channel below. Thank you so much for tuning in.